Hello?
Yes, sir. How I can help you?
Hello?
Sir, you don't need to keep saying hello. Just keep muted until the court starts.
Good afternoon, everyone.
Good afternoon, Your Honor.
Good afternoon.
Good afternoon, Your Honor.
Good afternoon. All right, we're ready to start. All right, ladies and gentlemen, we're going to begin our Fulton County State Court Expedited Accusations calendar. This is a calendar for cases that have recently been arrested and charged with certain misdemeanor offenses. Soon after their arrest, the Fulton County Solicitor General's office has already accused the cases of the offenses brought against them, and the case has been bound over to the Fulton County State Court. Nevertheless, this will usually be the defendant's initial appearance before a state court judge, so we are able to address several matters, including bond, possible arraignment, and a possible plea offer if one has been made by the state at this juncture. I will begin by letting everyone know what the SAP reset date is. Mr. Jordan,
September the 5th.
I didn't hear you.
September the 5th.
Okay, we can barely hear you. September the 6th or 5th?
September the 5th.
Fifth.
Can't hear you for some reason.
Can you hear me better now?
Yes, now we can. Okay.
It's September the 5th.
Okay, 5. All right. All right. I want to also remind everyone that this whole entire proceeding is being recorded as well as live streamed on YouTube, so govern yourselves accordingly. I want to remind the defendants that you have certain constitutional rights. You have a right to have counsel representing you at this juncture. You should know who your attorneys are by now. I also want to remind the defendants that you have a right to remain silent. Remember that anything that you state about the facts and circumstances or the occurrences of your case can and will be used against you. The state is here and they're listening. So follow the lead or instructions of your attorney. All right, deputies, who do we have first?
We can start with position number 21, Mr. Rhodes.
All right, this is 24 CR 005969J. Dayon Rhodes, charged with 1 count of theft by taking. Pretrial.
8 total. 2024 theft by taking. Trespass. You got an open case for trespass, transmitting false report of fire. It's 23 CR 005817J. Got an open driving without a valid license from 2022. On probation for shoplifting. And has a probation hold.
Driving what?
I got the wrong person. State, what you got?
That's what I have.
Okay. You got a probation hold. That's all.
All right. Okay.
Yes, Your Honor. In this case, the defendant is accused of stealing a GT Aggressor Pro mountain bike belonging to Rejoice Jones, valued at $700. Officers were able to get the bike and return it to the victim. However, given the defendant's arrest cycles and the fact that he just pled guilty to shoplifting last month, or I'm sorry, 2 months ago, and then proceeded to steal something else, the state's recommendation is a $1,500 surety bond, no further contact with the victim, no drugs, weapons, or alcohol while out on bond. And I would ask the court to sound for the victim, Ms. Rejoice Jones, if she is on the Zoom.
Hey, JB. I got
Joyce Jones. All right, go ahead. Is it PD Wills?
Yes, ma'am. Yes, Judge.
Uh-huh.
Mr. Rose is a native of Atlanta. He's currently unemployed. I do have some concerns for his mental health. I'm going to send out a request for a social worker to speak with him. I don't believe that there will be any further issue between himself and the alleged victim in this case. I would ask for a signature bond as he is unemployed currently. And he's also working on SSI. Obtaining SSI. So his funds are very limited, Your Honor.
So we're going to order a MHET or BHET?
An MHET, I think, would be more appropriate, but he did tell me his diagnoses. So it seems that he is working on it and is working, and he says he has an attorney that's assisting him with his SSI currently.
All right.
But, and also I just want to note, he does have stable housing that he provided and an address that he gave to me.
Okay. I will go ahead and order the $1,500 surety bond. We're going to order MHET. Does he need to be changed to the other calendar, Mr. Jordan, or we're going to leave him for SAP?
Oh, are they gonna request an evaluation? Or are they just talking about a social worker visit?
I think she's saying MHET, so she's going to request an evaluation.
Well, I am
Okay.
I'm not requesting an evaluation at this time. He already told me his diagnoses. He's working on that. So I would ask that that not be part of the good bond, but he does have a probation hold as well. But I am requesting that social worker go out and speak with him.
Okay, so that's the BHET. So let's do the BHET. Let them go out and speak with him to see if there's anything else they can help him with. I will order that he cooperate with any treatment and medication that he may need or may be ordered to take. No drugs, alcohol, weapons, unprescribed medication, weapons or guns, none of those while on bond. I'm going to order that he have no further contact with the victim in this case and stay away from, was it a bicycle shop?
It was just on the street, Your Honor. The victim had parked her bike there to help someone else, and then that's when the defendant proceeded to steal it.
Okay. All right. So just no further contact with the victim. That should be it.
And Your Honor, is there any way that we can do away with the BHET? I believe that we will be able to meet his needs with just a social worker visit. Since he knows his diagnoses, it seems that he might already have like a treatment and care plan that he's working on.
Okay. I'm getting mixed reviews when I first said that and you said yes, but I will remove it, but I'm going to put in the order that he must follow his plan of treatment and medication.
Yes, Your Honor. Thank you.
All right.
All right, let's get out of here. Next, we go with position number 2, Mr. Benz.
Yeah, come on, come on. Come on. What did I say? Green chair. Everybody sits in the green chair.
This is 24 CR 005962Y, Mark Benz, charged with 2 counts of simple battery, 1 count of willful obstruction, pretrial.
36, 2023 trespass, possession of cocaine, possession of drug-related objects. That's open. 24 SC 002297 on probation for burglary, 2nd degree. It's 22 SC 181742. 2023 probation, 2023 trespass, obstruction, conviction. And he got FTA hold and a probation hold.
All right, state.
Your Honor, he has 2 FTAs. One is on 24 SC 002297 for a possession of cocaine case out of Fulton County. And then one is a 23 CR 0000779J case. He has a $4,000 surety bond on that. He failed to appear for jury trial on July 8th of 2024. He also has that 1 probation violation hold, which is a felony probation violation hold with no bond. In this case, the officers were flagged down at 387 Cleveland Avenue in Atlanta, spoke to Amber Gray, who stated the defendant assaulted her for no reason. The officers reviewed the camera at that location, saw the defendant entering the store, saw Miss Gray approach the door, and then the defendant come back out of the door and proceed to choke Miss Gray. The defendant then released Miss Gray, went back into the store, and she followed him inside where words were exchanged. The officers then made contact with the defendant, tried to detain him. He fled from the police and was hiding at 410 Connell Avenue in Atlanta, Georgia, and was on top of the roof where he had to be taken off the roof and taken into custody. The state is requesting a $5,000 surety bond, $2,000 for each of the simple battery charges, $1,000 for the obstruction. Stay away from 387 Cleveland Avenue Southwest. No further contact with Amber Gray. We are also requesting an FVIP and no alcohol, drugs, or weapons. That's all for the state. We would like to sound for Miss Amber Gray.
Mr. Gray? Don't think she's on. All right, go ahead, PDs.
Good afternoon, Your Honor. I represent Mr. Benz.
Okay. Go ahead.
My client tells me that he is not in a position to pay anything significant towards bond, Your Honor. So a $5,000 bond for him is essentially the equivalent of no bond. So I would ask the court to consider giving him a lower bond so he just may be able to get out of jail. He tells me that he is employed, he works cutting grass, which is, it's not a job that pays a great deal of money, and that is his current situation, Your Honor. Of course, he denies the allegations in the warrant.
All right, I will order the $5,000 surety bond, 2,000 on each of the simple batteries, 1,000 on the obstruction. Stay away from 387 Cleveland Avenue. No further contact with Amber Gray. And no drugs, alcohol, weapons, or guns while on bond. That should be it.
Next, we can go to position number 22, Mr. Salazar.
Yeah. Slide down.
It's 24 CR 005970C, Rubiel Salazar, charge of one
Yes.
count of simple assault.
Yes.
6 total. Last arrest was 1979.
All right, state.
Yes, Your Honor. This incident occurred August 24th, 2024 at 6851 Roswell Road, Atlanta. The victim in this case is Ali Amin, who lives in the same apartment complex as the defendant. The victim states the defendant came to his door, and when he opened the door, the defendant tried to kick him, then slammed the door shut and went back to his apartment. The incident was recorded on video. The victim states that the defendant has confronted him about being too loud several times, even though the victim does not make any noise, and the defendant has also threatened to kill him in the past. The victim does live above the defendant in the apartment complex. The state's recommendation is a $1,500 surety bond. No further contact with this victim. Stay away from the victim's apartment. No drugs, weapons, or alcohol. And we would ask the court to sound for the victim, Mr. Ali Amin.
Mr. Amin. All right. Go ahead, PD Wills.
Yes, Judge. My client is 76 years old. He's resided in the state of Georgia for the past 12 years. He's retired. He lives in the apartment complex with his wife. So he suffers from depression. His wife struggles with depression and anxiety. This is more of a civil issue between neighbors. The alleged victim lives above my client. He states that he's very loud, he stomps, he makes a lot of noise that aggravates both my client and his wife's mental health conditions. So he went up to speak with him just to try to quell his concerns. And speaking with him, he states that he's not going to go back upstairs. He will not have any further contact. He's also looking into moving away from that apartment complex so he doesn't have to have any further dealings with the alleged victim in this case. My client is unemployed, he's retired. And so in light of that, Your Honor, I would ask for a signature bond. He doesn't have any criminal history that I've seen, or at least any significant criminal history, and none was stated on the record.
All right. I will order a $2,000 signature bond through the jail. I'm going to order no further contact with the victim, Mr. Amin, not to go within 200 yards of him. I know they live on opposite floors in the same building or complex, but Mr. Salazar, you're gonna have to stay away. If you see him coming, go the other way. No drugs, alcohol, weapons, unprescribed medication, or guns while on bond. And guess that'll be it for now.
Thank you, Your Honor.
Your Honor, I do have concerns with it being worded as the 200 yards, and they live above one another. So he would not be able to return home if he has to stay 200 yards away. Can
Didn't
it just be a no further contact?
let me look at something on the bond. order.
Maybe he could be ordered to stay away from the victim's floor since it's above his.
I would
Right,
agree with that, and I would agree with that, Your Honor.
okay. So not to go on the victim's floor. Shouldn't be upstairs or down, yeah, upstairs on that floor. Okay?
Thank you, Judge.
Mhm.
Next, we can go to position number 7, Mr. Cody.
This is 24 CR 005956D, Terrence Cody, 2 counts of simple battery. Pretrial.
Seven total. 2024 probation. On probation for possession of tools, burglary in the first degree. 2022 probation, 2021 probation, 2017 hindering emergency call, battery DV, simple battery DV, simple battery, trespass DV. All of them were convictions. There's one arrest. That's it.
State.
Yes, Your Honor, and that 2018 family violence battery was out of Hall County. In this case, officers were called out to 3601 Piedmont Road Northeast in Atlanta to a fight in progress. They spoke with Miss Beulah White, who stated that the defendant who she was dating showed up at the location and assaulted her. She identified him as the defendant and stated he showed up at her apartment, got upset with her, and he was upset because he found out she was talking to her neighbors and showing interest in them. She then stated he slapped her in the face with his hand multiple times, grabbed her by the neck with both of his hands so that he could try to choke her. They do not live together or share any children, and she does state that he comes through from time to time. Based on the fact that the defendant has a previous conviction for multiple counts of family violence battery from 2018, is currently on probation for that burglary, theft, terroristic threats and acts, and possession of tools case, we would ask for a $5,000 surety bond. That's $2,500 on each count. No further contact with Beulah White in a family violence intervention program, as well as no firearms and ADET. We would like to sound from Miss Beulah White at this time.
Beulah White. Beulah White.
And my apologies, Your Honor. And I believe I may have said no ADET. I meant no alcohol, drugs, or weapons.
Okay. All right, Miss White. Is that Miss White on the Galaxy? No? No. Okay. All right, go ahead, PDs.
Yes, Your Honor. My client, Mr. Cody, is an Atlanta resident. He has been here for his entire life. He does have a good job. He is a manager at Wingstop on Roswell Road. This is an ex-girlfriend now. He does not have any issues with no further contact. He also denies the allegations, and I find the veracity of them to be questionable considering there are no injuries in this case. It's simple battery. Mr. Cody cannot currently pay a bond. We would ask for a signature bond, and he actually does have injuries himself from this altercation. He's the only one with any visible injuries. He has swelling to his eye and on his shoulder. We would ask for a signature bond for anger management instead of FVIP. As you are aware, FVIP takes 6 months to complete. It's extremely expensive. And he is represented by the PD, meaning he is indigent. We would just ask for those conditions, and we don't have any issues with no further contact and a stay away.
And Your Honor, the stay away address is 3601 Piedmont Road Northeast in Atlanta, Georgia.
How old is Mr. Cody?
32.
I'm going to order the $5,000 surety bond, $2,500 on each of the charges. Stay away from 3601 Piedmont Road Northeast. No further contact with Beulah White. No drugs, unprescribed medication, alcohol, drugs, or weapons or guns while on bond. That's it.
You go. Next, we go to position number 10, Mr. Dillard.
This is 24 CR 005957C, Hassan Dillard, charged with one count of fair evasion, second count willful obstruction. Pretrial.
I got first. He's wanted out of Clayton County for battery though.
State.
We are totally fine with him going to Clayton County. We are agreeable to a $1,000, $1,100 signature bond, 1,000 on the obstruction of an officer, 100 on the fare evasion, and that he be released to his hold in, did you say Clayton?
Yes.
Clayton
Yeah.
County. He was at the West End MARTA station, refused to pay the fare, and the officer tried to arrest him, but he fled from the officer, but was caught by 2 other officers. That's all for the state.
All right. Any
Oh, and we
objection?
do ask that he stay away from the West End MARTA station.
Any objection, PD Holly, to the 1,100 signature bond?
Judge, I don't have any objection to the $1,100 signature. One procedural question. He did just turn 19. If he's being released to a hold, does he still need a cosigner?
It's through the
Probably.
jail.
No.
I mean, no.
Okay, I didn't think so, but I just wanted to double check because it was listed on his pretrial report that he needed one. I just wanted to make
Alright.
sure that they didn't
Okay.
need to come down.
No. We're gonna release him to his hold, $1,100 signature bond through the jail to be released to Clayton County jail. Stay away from the West End MARTA, and no drugs, alcohol, weapons, or guns while on bond.
Thank you.
Next, we go to position number 23, Mr. Williams.
This is 24 CR 005971H. Sir James Williams, charged with one count of simple battery family violence, pretrial.
6. 2022 obstruction, possession of marijuana. 2021 ag assault, trespass, reckless conduct, disorderly conduct. Those were DWAP. And 2020 battery dismissed.
Okay.
Yes,
State.
Your Honor. The victim in this case is Shondoria Jones, who was the defendant's girlfriend at the time of the incident, and the parties had also been living together. The defendant is accused of kicking in the victim's door, throwing her against several walls, causing damage to the apartment, and also pulling out her hair. Given the defendant's history, the state's recommendation is a $2,500 surety bond, no further contact with this victim, stay away from the incident location, which I have as 640 Boulevard Northeast, Atlanta, Georgia, and no drugs, weapons, or alcohol.
All right. PD Wills.
Thank you, Judge. I don't know if y'all wanted to sound for the.
Yes, please sound for the victim, Ms. Shondaria Jones.
Shondaria Jones. Nope.
All
Go
right.
ahead.
Your Honor, my client is a native of Georgia. He's currently unemployed, so he does qualify for our services. He is working on his GED. He is just 23. This incident did happen in July of 2022. There have been no further incidents between my client and the complaining witness. I would ask for a signature bond in this case. My client says that these allegations have been made up and fabricated against him and denies all allegations. And given just the time, now that we're August 2024, I believe a signature bond would be most appropriate.
All right. I will order a $3,000 signature bond through the jail. And
Jail.
I'm sorry,
The simple
guess-
battery.
yeah, pre-trial.
All right.
Your Honor,
You just said that.
I need to ask on the record, when was this case accused? Because if it occurred in July of 2022 and we're in 2024, that was after the emergency expired. Is this within the statute of limitations?
You do have a point there. It was accused today, August 24th, 2024. So it may be out of that
However,
window.
we are still waiting for the TLO to show us whether he was within the state the entire time of the incident, which, as you know, PD Wills would toll the statute of limitations.
All right. We'll look at that. I will give him a $3,000 signature bond through pretrial level 1. And order that he have no further contact with Shanderia Jones.
And I'm sorry, Judge, I didn't quite catch everything that Ms. Falk stated in regards to the SOL and
The TLO.
So under the statute of limitations, one of the provisions of tolling is if the defendant has not been within the state the entirety of the 2 years. We are currently running a TLO, but have not received our TLO back from our investigators to demonstrate whether or not he was within the state for that period of time. If he was, that would toll the statute of limitations, which, as you know, would allow us to proceed with prosecution.
okay, my understanding is that didn't it end 6/30/2021?
So the provisions that regard the statute of limitations are different from what you're talking about, which is pandemic tolling. The provisions that regard the statute of limitations have exceptions where the defendant cannot be found within the state, where the defendant was not identified initially, or where the victim did not know who the defendant was. So those are the provisions that allow for the exception to the tolling. I'd be more than happy to put the statute in the chat for you if you need to look at it, but those are the provisions that allow for the exception to the tolling.
No, I do appreciate the additional context and you explaining that. I'll add a note just for the attorney that this case will be going to look into those statute of limitation issues. I appreciate Your Honor for granting my client a signature bond.
Okay.
And I'm sorry, it was a $3,000 signature bond. What were the other provisions? I apologize.
The pretrial level 1.
Okay.
And to have no further contact with Shanderia Jones. I don't know if there was a stay away requested or not.
There was a stay away from the incident location, which is the victim's residence. And that was 640 Boulevard Northeast, Atlanta, Georgia.
All right, and stay away from the incident location.
Thank you.
All right.
Next, we can go to position number 14, Mr. Methalen.
McCullen.
Methalen.
This is 24 CR 005963J, Jason McClellan, charge of 1 count of loiter and prowling.
2022 simple battery. 2019 probation. 2010 simple battery. Hindering 911 call conviction. 2009 battery. Cruelty to children conviction.
All right, state.
Yes, Your Honor. This incident occurred August 23rd, 2024 at the Children's Learning and Adventure Center located at 13175 Cogborn Road in Milton, Georgia. The defendant is accused of loitering at the incident location. He hopped over the fence, entered the building, and was walking in and out of the building. He told officers that he was on a retreat to find God and that there was someone trapped inside the bathroom of the building. He also told officers that he had a friend named Mike who lived at St. Vincent de Paul, but when he went to Mike's house, Mike refused to let him in. He stated that people had told him to enter the building and search for the person pretending to be God. He did admit to officers that he had smoked some methamphetamine earlier in the day. Given the facts of this case and the defendant's history, the state's recommendation is a $1,500 surety bond, stay away from that incident location, an ADET, and no drugs, weapons, or alcohol while out on bond.
All right.
Judge, may I request a brief sidebar with the court in a breakout room about this case?
All right. Mr. Jordan, you put us in a breakout.
I'm assuming this is breakout with the ASG's office?
Yes.
Okay, that's just checking.
All right, Mr. McClellan. I'm going to tell you, we discussed your case in the breakout for some confidentiality reasons. And I'm going to order a $1,500 surety bond. I'm going to order that you stay away from 13175 Osborne Road, I believe it was, in Milton, which would be the incident location. That you have no further contact with the victim in this case.
There is no victim in this case, so there wasn't no further contact. And the address was 13175 Cogborn Road. I'm not sure.
Could not hear it. COG?
Yes, Cogburn.
Okay, Cogborn. All right, stay away from that address. No drugs, unprescribed medication, alcohol, weapons, or guns while on bond. Okay, all right.
Your Honor, what, it's 2 charges on his booking sheet. Was the criminal trespass NOD?
Yes, the criminal trespass was NOD.
You can have a seat in the third one.
Okay, thank you, ma'am.
Uh-huh.
Please go to position number 16, Mrs. Myers.
This is 24 CR 005965D. And this is for Marvis Myers, charged at 1 count of simple battery, family violence.
4th arrest, last was in May, hit and run. It's 24 CR 003055D, 05 fleeing conviction. That's it.
Dave?
Yes, 1 second, Your Honor. I'm just pulling up my notes.
Okay.
Yes, Your Honor. This incident occurred May 27th, 2024. The victim in this case is China Meyer, who is the defendant's daughter. The victim and the defendant had gotten into a verbal dispute regarding the victim's minor child. The victim advised that the dispute became physical when the defendant began punching the victim in the face and pulling her hair. The victim said that her grandmother put her and her child in the bathroom to separate the parties, but the defendant came into the bathroom and continued hitting the victim and even hit the victim's child at one point, and while she was holding her. The victim did complain of injuries to her neck, but the officer did not note any visible injuries when the report was being taken. I will note that the report was taken 3 days after the incident. Our office has had an opportunity to speak with Ms. Myers. She states that the parties both reside at the incident location. They do not have a DV history. She is not afraid of the defendant. She did confirm the events of the warrant, but stated that she wants to continue contact and wants the defendant to return to the residence. The state's recommendation is a $2,500 surety bond. Given our conversation with the victim, the recommendation is for no further violent contact. Anger awareness, at least 1 day, might be beneficial to this defendant. No drugs, weapons, or alcohol. And I would ask the court to sound for the victim, Ms. China Meyer.
All right, China Myers.
Yes.
All right, he's showing up as Nicole. Need to ask you a question. Need to ask you one question first. Yes or no, do you wish to address the court today?
No.
Okay. All right, you can turn off your camera and put yourself back on mute. Thank you. PD?
Thank you, Your Honor. As has been stated, my client, this incident happened back in May of 2024. There have been no further issues between my client and her daughter since then. My client tells me that the alleged victim, as well as her 2 children, live in the home with her, and they have been there since this alleged incident. they still want to have contact. They have had contact. There's been no further issues or concerns between the two of them. My client is a native of Georgia. She does have employment. She actually has to be at work later today, just hoping to be bonded out tonight as she supports her children and grandchildren in the home where they currently live. She also has a high school diploma and does have some college courses that she has taken. And so in light of all of that, I would ask for a signature bond. My client also states that the alleged victim was the aggressor in this incident.
All right. And Myers is the mother and daughter. Okay. I will order the $2,500 signature bond through the jail. I will order no further violent contact with the victim and the defendant. Hopefully this is all blown over and they'll be able to live in peace together. I will order no drugs, no unprescribed medication, alcohol, or weapons while on bond. That's it.
Thank you, Judge.
Next, we can go to position number 20, Mrs. Price.
'24 CR 005968B, Deandra Price, charged with 1 count of criminal trespass and damage to property. Pre-trial.
First, jail.
Okay. State.
Yes, Your Honor. This incident occurred August 3rd, 2024. The defendant in this case, her mother used to date the victim and they used to live in the same residence. The victim and the defendant's mother are currently not getting along at this time. The defendant was seen on video using a screwdriver to break open the gas tank and break off the locking piece of the victim's motor vehicle. The defendant is also seen on video walking with a funnel and a plastic container of clear liquid and approaching the gas tank. However, the video cuts off before anything is done. She is also seen ducking next to the victim's tires. Nails and screws were found under the victim's tires. Our office has had a chance to speak with the victim in this case, Mr. Morick Payne, who stated that he has known the defendant for 10 years, of course, used to date her mother. He never had a problem with the defendant until this incident. He did confirm the events in the warrant and stated that his vehicle is damaged. The vehicle is registered with Uber, so this incident has hindered him from working. The victim stated that he wants no contact and wants the defendant to stay away from his residence. The state's recommendation is a $1,500 SOB through pretrial services, 2-day anger awareness, no further contact with this victim, stay away from the incident location, which I have as 3490 Somerset Trail Southwest, Atlanta, no drugs, weapons, or alcohol while out on bond. I would ask the court to sound for the victim, Mr. Morick Payne.
All right, is it Pine?
Yes.
All right. Do you wish to address the court today, yes or no?
No.
Okay. All right, continue listening in on mute. PD Wills?
Your Honor, we have no objection to a signature bond. My client tells me that Mr. Pine does not live at that residence. So my client is the daughter of Mr. Pine's wife or former girlfriend. She states that there's actually an order in place where he cannot return to that residence. So there should not be any issue with her going back there. She states that she was defending her mother. There have been prior difficulties between Mr. Pine and my client's mother. So again, we would not object to the 6-year on bond. However, I would ask that my client be allowed to return home to live with her mother. She is just 24. They've been here since 2018. My client is employed. She does have a high school diploma and some college.
If we could just possibly confirm with Mr. Pine that he does not live at that residence.
Yes.
You don't live at that residence.
No, not anymore. Since October, August 3rd.
Okay, thank you. So then, of course, we would move to strike the stay away provision.
Okay.
And then furthermore, I just would like to add, he's not allowed back there by an order that's been put in place. He has, according to my client, vandalized the home, and there has been some prior domestic violence issues, which may have contributed to some of the events that occurred on this date, but my client does not admit any guilt to anything that she has done. Or I'm sorry, does not admit any guilt to anything that's been alleged against her, excuse me.
All right, I will order the $1,500 signature bond through the jail. And I will order no drugs, unprescribed medication, alcohol, weapons, or guns while on bond. And with the victim, I guess there was no further violent contact.
No further contact, Your Honor.
No further contact. Okay. No further contact with the victim. Anything else?
Nothing from the state, Your Honor.
No, Your Honor,
Alright.
thank you.
Your Honor? We can go to position number 15. Mrs. Moore.
This is 24 CR 005964E. Latoya Moore, charged 2 counts of battery family violence, pretrial.
4 total. On probation for battery DV, cruise in the third, 22 CR 005751E. Got 12 months probation back in March for that. On probation and also for reckless conduct, 21 CR 006270E. That started back in March as well. And the 2022 battery DV arrest. That's it.
Okay. State.
Yes, Your Honor. This incident occurred August 23rd, 2024 at 561 Arthur Street, Southwest Atlanta. The victim in this case is Ziona Grant, who is the defendant's daughter. The defendant is accused of throwing a pair of headphones at the victim, which caused them to break against the victim's neck, striking the victim multiple times, and also biting the victim on the leg. A witness to the incident who had to break up the parties advised that the defendant was the primary aggressor. The victim sustained a cut on her arm, a bruise on her hand, a busted lip, and a bite mark on her leg. Both the victim and the witness advised that the defendant had been drinking, and the officers observed a liquor bottle in the defendant's hand. The defendant's battery family violence case 22 CR 005751E, which she pled guilty to on March 7, 2024, was against this same victim, Ziona Grant. She is in violation of the probation conditions, I believe, which stated she was supposed to have no further contact with this victim, Ziona Grant. So she violated that condition when she committed this battery family violence offense on August 23rd, 2024. Her office has not had a chance to speak with Ms. Grant, but based on the fact that she had a prior family violence conviction against this same victim, the state's recommendation is going to be a $5,000 cash bond. Absolutely no further contact with Ziona Grant. stay away from the incident location if the victim still lives there. A police visit to make sure the victim is not living there would be requested, either an FVIP or anger awareness, and no drugs, weapons, or alcohol. I would like to point out that we did speak with the witness, Mr. Kenneth Fisher, who is the defendant's boyfriend, and he does reside at the residence with the defendant. He stated that the victim had been living there for about a week. And that is why we are requesting a police escort to see if the victim is still there. And if the victim isn't there, of course, then the defendant can return to the residence. And I would ask this court to sound for the victim, Ziona Grant.
Diana Grant. All right.
Yes, Your Honor. Miss Moore is 39 years old, and she does have 5 children. This child, who's 16, does not reside with her normally, as the ASG stated. This is her boyfriend, Kenneth Fisher's house. It's not the residence of her daughter or any of her children. She does have a job working at McDonald's, but she does not make very much. She certainly cannot afford to pay a cash bond. She doesn't have any issues, and we discussed the no further contact, and that being essential, and that it would be no further contact at all. What we would ask for at this time, based on her indigency, is a $5,000 signature bond, but we leave it in the discretion of the court.
And this, and the relationship between her and the victim,
Mother
is
and daughter.
mother and
Mother
daughter,
mother.
but they don't live together.
They do not live together.
No, they don't live together. And again, she was already ordered to have no further contact as a part of her probation, and she had contact with her daughter and then proceeded to beat her up.
And the state is asking for a 5,000 cash bond.
Yes, Your Honor. Given that she already has the battery family violence conviction against the same victim. And we did recommend a felony transfer given that conviction. We just haven't heard back yet.
All right, I will order a $10,000 surety bond. I'm going to order again, no further contact with the victim. Stay away from, was it Arthur Street?
Yes, stay away from Arthur Street unless the police can go there and confirm that the victim doesn't live there. Based on the conversation with one of the witnesses, the victim.
Did the state, didn't y'all talk to the owner of the home and he said she's not living there?
He said she'd been there for a week, and that he hasn't seen her since, but we do want to confirm, because she is the victim, that she is not living there. And of course, if she doesn't live there, the defendant can go back to the residence.
Okay, and so defendant will get a one-time law enforcement escort back to the property, sweep the property, make sure that the victim does not still reside there or have any belongings there. And if the victim does not, then the defendant can stay there. No drugs, alcohol, unprescribed medication, weapons, and guns while on bond. And I think that's it. Anything else, counsel?
Nothing further from defense.
Nothing from the state, Your Honor.
Okay.
Next, we will go to position number 11, Mrs. Edwards.
Eleven 24 CR 005958C, Nakia Edwards, charge of 1 count of driving, striking unattended vehicle. Pre-trial.
Second, last arrest was August 16th. Ag assault, trespass, battery, DV. Let me see. This is the third arrest. 2013 shoplifting. And jail is a recommendation.
State.
Yes, Your Honor. In this case, this incident happened back on August, wait, let me make sure I have the right date, July 16th of 2024. On that date, officers were called out in regards to a 2024 Honda Civic being struck while parked at the location of 1550 Peachtree Street Northwest. The vehicle was parked there between 10 a.m. and 4:15 p.m. And the victim, Mr. Dallin Delgado, stated the vehicle was struck while he was there. Officers did receive a link to upload relevant video footage in that case. And upon reviewing the video footage, they observed a white four-door sedan appearing to be a Kia backing into a handicapped parking space and striking the vehicle as it was backing up. The driver then pulled forward, repositioned back into the space without any further contact. The officers utilized tag readers to find the tag CSD 6089, which belonged to Miss Nakia Edwards. When they reached Miss Nakia Edwards, she stated she did make a delivery on the date and time, and she is the only person that drives the vehicle. She also stated she did not recall striking the parked car and agreed to meet with the officers. However, she never showed up for the meeting, and they also saw she had existing warrants from the DeKalb County Sheriff's Office. So at that time, warrants were taken out for her on this case. I believe that currently she has no bond on this case. We would be agreeable to a $1,000 signature bond through pretrial services, as well as a stay away from that address, which is 1550 Peachtree Street Northwest. Further contact with Mr. Dallin Delgado, no alcohol, drugs, or weapons. We would like to sound for Mr. Delgado at this time.
All right, Mr. Delgado. Mr. Delgado. All right, he's not on. PDs?
Yes, Judge, we obviously are in agreement with it being a signature bond. I would request that it be through the jail. This is essentially a traffic case. Ms. Edwards is not, she did speak with the officer and did intend to go to the meeting. Her best friend actually passed away and she was at the funeral and did miss the meeting. So she is not arguing with that. She was not aware of the outstanding warrant that was for her in DeKalb. She's been in custody since then, but she has already paid the bond on the DeKalb case. So we're consenting to the $1,000 signature. I would request that, I'm not sure if I heard Deputy Falk ask for a stay away, but that a location of the incident is my client's job where she does deliveries. So I would ask that she be allowed to revisit that location.
Okay, then we will be agreeable to lifting the stay away, but maintaining the no further contact.
Yes, and that's not a problem.
Okay, so it's a $1,000 signature bond through the jail. No further contact with the victim. And no drugs, alcohol, weapons, or guns while on bond.
Yeah, one more.
And I think that's it. Anything else, counsel?
That's it. Thank you, Judge.
Nothing.
Okay.
Next, we can go to position number
Next, Judge, we're gonna do number 4, 5, and 6, Ms. Bueno Lopez.
PD Holly, is this your case?
It is my case.
Does the defendant still reside at that location?
She does.
Really? Okay.
All right, this is 24 CR 00595-3B. Janice Buena Lopez, charged with 1 count of theft by taking.
First, jail.
Okay.
She's got
Okay.
2 of this because
She has what, Mr. Jordan?
which position are we on?
We are on 4.
4, 5, and
Well,
6.
You have
it's
5
4,
and
5, and
6.
5 and 6.
I can go ahead and sound for 5 and 6, okay. So that's at 24 CR 005954B, theft by taking, 722, 24, and then 24 CR 005955B, theft by taking on 8/14, 24. And the first one that I read was 7/17, so
That is correct.
I guess July and August.
Mhm.
Okay.
So, Your Honor, on July 17th, on July 22nd, and on August 14th, the defendant entered the mailroom at the 131 Ponce de Leon Avenue Northeast location, which is the 131 Ponce de Leon apartments. She was seen on video surveillance on all three of those occasions, taking items out of the mailroom without the consent of the person who owned those items. In the first instance, it was work uniforms, Delta work uniforms belonging to Ives Hubbard with a value of $200. In the second instance, it was a box of skincare products belonging to Antonio Jones Moore with a value of $600.27. In the final instance, it was a box containing a Dyson vacuum cleaner belonging to Pamela Islas with a value of $653. The defendant was identified in all of these instances by Jason Colazzo, the leasing agent, who was able to identify the defendant and state she was a current resident at the time of all these incidents. We would ask for a $3,000 signature bond through pretrial services, $1,000 per count in anti-theft course, no further contact with Ives Hubbard, Antonio Jones Moore, or Pamela Islas. That's all for the state. We would like to sound for Pamela Islas, Antonio Jones Moore, and Ives Hubbard.
Are any of those victims on the line? All right, go ahead.
And Your Honor, just to clarify, the 1,000, it's 1,000 per case for a total of 3,000. I may have omitted that, so I apologize.
It's okay. All right, is there any dispute, PD?
We don't have any dispute with anything other than the theft class. That's a probation condition, not a bond condition. We would ask that that be removed. Otherwise, we're good with everything else.
All right. So for each case, $1,000 signature bond through the jail on each of
Well,
the
Your Honor,
cases.
PD Holly consented to a pretrial services bond, so that's what we were asking for.
For the anti-theft class or for the 1,000?
No, we were asking for a $1,000 signature bond through pretrial services.
Oh,
That's
I
what
see.
the state was asking for on each case. PD Holly said she didn't disagree with that, so that's what we're asking for.
I don't have a problem with it being through pretrial.
All right, and the anti-theft class will be free through pretrial, correct?
That would be correct.
Okay. So for each case, $1,000 signature bond through pretrial, level 1, and the anti-theft class through pretrial services. No drugs, alcohol, weapons, or guns while on bond.
And no further contact, Your Honor, with those 3 victims.
And no further contact with the victim in each case. And I guess do not take any more packages.
Judge, what was the total?
Belong to
3,000.
3,000, 1,000 on each case.
And you said signature bond through pretrial, correct?
Yes.
Thank you.
And is there a stairway or was there no stairway?
She lives at the location.
No, she resides there.
Thank you.
Next, we can go to position number 13, Mrs. Cam.
All right, 24 CR 005973F, Gerda, Concom, 1 count of battery, family violence, pretrial.
First.
Okay. State.
Yes, Your Honor. This incident happened back on August 23rd, 2024 at 1400 Riverwood Lane, Unit H in Roswell. This incident occurred when the defendant, hold on just a moment, Your Honor. Apologies, I have a little bit of a whiny dog next to me. All right. So there was an incident where the two of them have been dating for the last 8 years, but living together for the last 3 months. They were sleeping in the same bed, but the defendant, apparently the victim did not want companionship, Mr. Albert Arthur. So he got up, tried to leave. She got upset with him, began wrestling him, and bit him. They did speak with Mr. Albert Arthur, and observed bite marks on his right arm. Both upper and lower teeth marks were visible on his arm. They asked the defendant what happened. She stated that while ushering him out of the apartment, she pushed, pulled, and bit him. And then she stated he kicked and hit her during that incident. No marks could be observed on any visible portion of her body. As this is her first offense, we are agreeable to a $3,000 signature bond through pretrial services, 1-day anger awareness, no further contact with Albert Arthur, and a stay away from 1400 Riverwood Lane, no alcohol, drugs, and weapons, particularly no firearms. We would like to sound for Mr. Albert Arthur at this time.
Mr. Albert Arthur.
And if he's not there, it's my understanding that he's been trying to get into the jail to speak in regards to this case. I did have contact with him this afternoon. He called me stating that they would not allow him in to testify on Ms. Kenkem's behalf.
Who is on the Zoom as Galaxy S23?
And we couldn't just send him a Zoom link for him to appear?
He has difficulties with his connection and telephonic issues, so he thought it would be easier for him to appear in person. And speaking to him was very choppy when I tried to talk to him.
Well, no, we'll keep moving.
Did he express any desire one way or the other in regards to the?
He did. He does desire. He expressed to me that he does desire to have contact and remain at the residence. It's my understanding, speaking to my client, that that's actually her apartment. Her name is on the lease solely. This was an argument over a blanket that escalated beyond either one's, I guess, beyond what they anticipated. Both my client and the alleged victim desire to have contact. My client doesn't have a violent history. She doesn't have any history. She would like to be able to return home. Mr. Arthur has been residing there for the past couple of months. And so I would be requesting a signature bond. My client is employed. She works for Westdale as an asset management, as well as a leasing consultant. She's been there for close to a year now. She has an associate's degree. This is kind of a one-off type situation where I don't believe there will be any further difficulties between my client and the alleged victim.
And Your Honor, as you well know, the fact of whose name's on the lease is irrelevant in a domestic violence situation. I would like to hear from the victim if he could join the Zoom, even briefly. Anything's better than just not being here at all, since we have also not been able to get in contact with him. But the state agrees to a signature bond. It's just the terms, whether there is a stay away and a no further contact or not.
Yes, Your Honor. And as an officer of the court, I have spoken with Mr. Arthur and his brother. So I had to call his brother to get in contact with Mr. Arthur, who called me. I can make arrangements if the court would like to hear from Mr. Arthur. I can attempt to call his brother and see where Mr. Arthur is at this time. But he did state that he was en route to the jail and was trying to seek access into the jail to speak on my client's behalf.
All right. I will order that 3,000 signature bond. I guess I will order it through pretrial or jail. I'm trying to figure out, I want her to take a anger awareness course. Which
Well, Your
would
Honor,
be
since this is an SB 63 case, family violence battery, it would need to be ordered through pretrial services.
all right, through pretrial, and then a 2-day anger awareness course through pretrial.
Boy, Christ Almighty, come on. What was the bond amount?
I'm sorry?
Bond amount?
Oh, 3,000 signature bond through pretrial.
But the judge hasn't finished
I hadn't
pronouncing the
finished,
bond
yes.
order.
Okay, and so we're gonna have a no further violent contact with Albert Arthur. And then I guess we won't do the stay away since he's okay with that. And no drugs, alcohol, weapons, or guns while on bond. Okay.
Thank you, Judge.
Thank you, Your Honor.
Did you have a question about the bond?
What level?
Oh, level 1.
Next, Judge, we have number 8, Ms. Davis.
Okay. This is 24 CR 005972F, Imani Davis, charge of 1 count of battery and a 2nd count of willful obstruction. Pretrial?
11 total, 2023 battery. 2023 FTA, 2023 battery that was dismissed. 2023 trespass damage conviction. 2020 battery DV conviction. 2019 affray conviction. 2019 trespass obstruction conviction. 2015 disorderly conduct NOLO. And a 2015 CWAC first offender.
Okay.
Your Honor, this incident happened back on August 23rd at 254 Peachtree Street in Atlanta. Officers went to that location, witnessed 2 females involved in a physical altercation, and observed the defendant strike a Miss Jane Doe in the face while causing a laceration above her left eye. The defendant was placed into handcuffs, and she resisted by failing to stand up and dropping her weight down and refusing to cooperate. Miss Jane Doe was also taken to Grady, at which point she was released from Grady, and the defendant was transported to the jail. Given the circumstances, Your Honor, the state is agreeable to a $3,000 SOB through pretrial services, stay away from 254 Peachtree Street, 2 days of anger awareness, no alcohol, drugs, or weapons. I do not believe Jane Doe is, well, Jane Doe's real name, so we don't have a no further contact because I'm not sure exactly what the name is, but we are looking into that and doing further investigation. That's all for the state.
All right.
Yes,
Yeah,
Judge, we don't have
objection
any
to that
objection
signature?
to, sorry.
Yeah, go ahead.
We don't
signature
have
bond.
any objection to a pretrial signature bond. As far as any stay away, this happened in front of Gateway Behavioral Health, where my client is currently in treatment. So we would ask that there not be a stay away from there. The other person who this fight was with, my client does not know, and that person was 1013 Jane Doe. We don't know her name. That I do believe that there's an argument to be made that that person was having an episode, significant episode, and initiated the altercation. But we're totally amenable to all of the other terms. Totally fine with, as long as it's a signature bond and no stay away, so she can continue getting treatment at Gateway.
Okay.
And Your
All
Honor,
right.
it would be a $2,500 signature bond on the battery, $500 on the willful obstruction
All right.
for the breakdown.
For the breakdown, right? I will order that $3,000 signature bond through pretrial, 2,500 on the battery, 500 on the obstruction. With that signature bond through pretrial, the 2-day anger awareness course, and no drugs, alcohol, weapons, or guns while on bond. Just make it a 1 day. Well, actually, I don't know if, it sounds like she wasn't the aggressor, but just do a 1 day. It's free through pretrial.
Well, it need to be level 2, and it's per judge due to the violent criminal history convictions in the past Weird.
Yeah, that's why the state asked for a 2-day.
Okay, well, let's go back to the 2-day. 2-day, level 2. We'll do that
It's per judge, Michael.
per judge. All right,
Thank you, Judge. We're completed here at ATDC.
all right, thank you.
Next, we can go to position number 1, Mr. Banks.
This is 24 CR 005961G, Adrian Banks, charged with 1 count of simple battery, 2nd count public drunk.
Fourth
Your
arrest,
trial.
03 suspended license.
State?
Your Honor, this happened August 22nd, 2024. Officers responded to 609 Virginia Avenue Northeast in regards to a verbal and physical altercation. They met with Miss Finney Cooks, who stated she had been assaulted by the defendant. She stated she was listening to music in an Uber, and the defendant flashed a phone flashlight in her eyes and accused her of stealing marijuana from the vehicle. The accusation escalated into a verbal dispute where the defendant then tried to go through Miss Cook's purse searching for the alleged marijuana. The witnesses who were on the scene observed the defendant restraining Miss Brooks by wrapping his arms around her neck and mouth in an attempt to control her and to imprison her. In an effort to free herself, she ended up having to bite him multiple times on his forearm. And witnesses, including Steph Mold, Melanie Clinton, and Jacob Miller, indicated they heard her screaming for help and rushed outside of their apartments and observed him forcefully grabbing and shaking her while restraining her. So she was assisted by these multiple people. They were able to detain him and place him into custody, and he was visibly intoxicated when the officers made contact with him. Although the defendant does not have an extensive or even recent history, the events of this situation are just beyond concerning. This is a person who does not appear to really have any sort of, at least from the warrants, any sort of relationship with this defendant when all of this happened. Multiple individuals witnessed the incident and had to physically intervene to stop it. So the state would ask for a $4,000 surety bond. We do ask that the breakdown of that bond is on $3,000 for the simple battery, $1,000 for the public drunk, no further contact with Finney Cooks. Stay away from the apartment complex at 609 Virginia Avenue Northeast in Atlanta. No alcohol, drugs, or weapons. That's all for the state. And we would like to sound for Miss Finney Cooks if she is here.
Okay, Miss Finney Cooks. All right, go ahead, Attorney McLeod.
Yes, Your Honor. My client is 44 years old. As Petrala stated, he has no criminal history. He apparently has been arrested a long time in the past for driving on a suspended license, but he certainly has no criminal history, Your Honor. His version of the events differs significantly from what the state has said. He tells me that he was in a shared Uber with the alleged victim, and the driver of the Uber told him that he had dropped something in the back of the car and asked him to look for whatever it was that he had dropped. So he put the flashlight on his phone and was looking for whatever the driver said that he had dropped. And that was when the alleged victim took offense to it. So they got in a verbal argument and she was attacking him. He was just trying to restrain her, Your Honor. Someone who has lived for 44 years, getting into any trouble with the law is clearly not someone who is a danger to anyone. He does not know this young lady and he admits that he doesn't know her. There's no reason for them to be in contact ever again. So I would ask the court to consider giving my client a signature bond so he can get out of jail. He is gainfully employed, Your Honor, and he is a native of Atlanta, lives here, has ties to the community. Nothing further, Your Honor.
All right. I understand he had four cycles, but the 03, I think, was the
Yeah, I'm back now. 03
Don't
was the
all
last
about a
arrest.
suspended license, Your Honor.
All right. No violence.
No.
I will order that $4,000 signature bond through the jail. 3,000 on the simple battery, 1,000 on the public drunk. No further contact with the victim. Is it Finesse Cook? Wasn't sure how to spell it.
Finney, Fini, Cooks, Cooks.
Finney Cooks. And no further contact with her. No drugs, alcohol, weapons, or guns while on bond. Something tells me that I want to order him to take his own anger awareness course at his expense. Can you do that?
Your Honor, the thing is, it seems like what he's simply charged with disorderly conduct. What he says is that she was the one, he was just looking for the driver said he dropped something and he was just looking for it. I didn't see that there was necessarily any anger here. Even the state says he was just trying to restrain her. She bit him, she attacked him. He's 44 years old, has no history whatsoever of violence. Or
Sorry,
even anger issues.
were we listening to the same case? Because three individuals
Yes, we
had to
were.
intervene and grab the defendant away from the victim, who he was forcibly grabbing and shaking, which I stated in my recitation of facts.
Yeah.
Yes, but she was biting him.
Because he was forcefully grabbing and shaking her.
Miss Falk, I don't know if you heard what I said happened. They were actually
I
in an
heard what you
Uber
said.
when
I
it
just
first
have three
started.
witnesses who would disagree with that recitation of facts that you provided.
Of course, whenever there's an incident that involves males and females, people automatically assume that the man is wrong without finding out what happened. It doesn't sound like my client is a violent person at all.
Well, it doesn't sound like he's a calm person either. So I think it's somewhere in the middle there. I'm going to order him to take a one-day anger awareness course. I believe he should be able to afford that because there's something going on here. I don't think it's quite that simple that he was just defending himself. That may be why he ended up in jail, but I'll order the $4,000 signature bond through the jail with a one-day anger awareness course, 3,000 on simple battery, 1,000 on the public drunk. And that's it.
Thank you, Your Honor.
Thank you, Your Honor.
Next, we can go to position number 19, Mr. Plummer. Third row, sir. Third row, folks.
You said 17 or 19?
19.
Plummer. Okay.
All right, that is 24 CR 005974G, Franklin Plummer, charged with 1 count of battery family violence, pre-trial.
19 total. Got an open suspended license. Got an open battery in state court 20 CR 004 860G. On probation for robbery, ag assault 24 SC 001196.
All right, stay.
Hold on. Hold on.
Not done?
No. Oh, no. Also on probation for ag stalking, aggravated assault, strangulation, ag assault, family violence, 2 counts. 21 SC 177895. 2023 probation, 2022 probation. 2011 ag assault with intent to rob, possession of a firearm during the commission, criminal attempt to commit a felony, first offender. 2010 ag assault, first offender. That's it.
All right. State.
Yes, Your Honor. This incident occurred July 12th, 2024. The victim in this case is Tiffany Smith, who shares children with the defendant. On this particular day, the parties and their children were driving on Campbellton Road when they started arguing, and the defendant began punching the victim in the face and also bit her on her cheek. Officers did observe a hole in the side of the victim's lip that was bleeding and a bite mark on her left cheek. The inside of the vehicle showed signs of the altercation with blood on the passenger side of the seat. The open case that the defendant has, the battery family violence 120 CR 004-860G, is with this same victim, Miss Tiffany. I apologize. I think I said her name was Tiffany Smith. Her name is Tiffany White. And that battery family violence case that is open is with that same victim as Tiffany White. The 21 SC 177895 conviction for ag stalking, ag assault strangulation, ag assault family violence, and criminal trespass is again with this same victim, Miss Tiffany White. The defendant is currently on probation and was ordered to have no violent contact with the victim, so he is in violation of his probation. The state's recommendation, given the fact that the defendant has 2 violent cases that we know of against the same victim, and he has a history of multiple violent arrests and convictions, is a $10,000 cash bond. We are extremely concerned for this victim and the party's children. No further contact with this victim, no further contact with the children that they share. Stay away from the victim's residence, an FVIP, an ankle monitor to ensure that he has no contact with this victim, and no drugs, weapons, or alcohol. And I would ask the court to sound for the victim, Ms. Tiffany White, at this time.
All right, Tiffany White. Tiffany White. All right, go ahead, PD.
This is my case, Your Honor.
Oh, sorry, Attorney McLeod.
As the status stated, Your Honor, this incident happened some time ago. I believe they said in July or early July, this incident was supposed to have happened. My client tells me that he shares 2 young children, a 3-year-old and an 8-month-old, with the alleged victim. They do not live together, Your Honor. He denies the allegations in the warrant, and he says that is not what happened. He said that the mother of his children became upset on the day in question because she saw him speaking with the mother of his other children. He does have 3 other children, Your Honor, with someone else. And she happened to see him speaking with this person, and she became upset. And this was what happened. So she was the initial aggressor in all of this, and he was merely defending himself, Your Honor. I believe that the $10,000 cash bond is excessive under the circumstances. He definitely is not in a position to post that kind of bond, although he is working. Most people who are not millionaires can hardly come up with $10,000 in cash. Some people cannot come up with that even in credit, Your Honor. So obviously, if it remains as a $10,000 cash bond or any kind of cash bond, he will be sitting in jail. He does have some children to support, so it would not benefit those 2 children, one of whom is only 8 months old, if he is sitting in jail, unable to get out and go back to work. Nothing further, Your Honor.
And of course, Your Honor, the state's recommendation is based on the defendant's history, which includes 1 open case against this victim and 1 conviction against this victim. There is a concern that he will reoffend. There is a concern that he will intimidate this victim. And again, his criminal history speaks for itself.
Yeah, I am concerned. This is not his first case, and not his first case with the same victim. I'm going to order a $5,000 cash bond. And I'm going to order once again to stay away from Tiffany White. No further contact with her. And no drugs, alcohol, weapons, or guns while on bond. And I didn't write down, there was no stay away address, just a no further contact.
There is a
Not
no
live together,
he asked for a stay away from the victim's residence. I don't know what that address is, but whatever that is, he needs to stay away. And also, we did request either an FVIP, but if you're not inclined to give an FVIP, at least some anger awareness at the very least.
Mr. Plummer, you have the right to remain silent,
I don't even
and I
know.
suggest you don't say anything.
don't know if it would do any good at this point. Stay away from her address, her home address, and her work address. Stay 200 yards away from her.
You know, I was going to say, at the moment, the alleged victim is in the state of Texas.
Okay, well, good.
He should have no
He can
problem
do it.
staying away.
Yeah, 200 yards. I won't order a course at this point.
They do not live together. And they have not lived together. They were not living together.
Your Honor, can I say one thing?
No. Mr. Plummer, you have the right to remain silent. If you have any questions or there's anything that you think I should bring to the attention of the court, you need to tell me that privately.
All right, that's it.
Thank you, Your Honor.
Mm-hmm.
And that concludes my business before the court today. May I be excused?
Yes, you may. Thank you.
You're welcome. Thank you.
Mm-hmm.
Next, we can go to position number 18, Mr. Palmer. 1-8.
This is 24 CR 005967Y. Timothy Palmer. Georgia, 1 count of pedestrian in the roadway, 2nd count willful obstruction.
What
Pretrial.
about 17? I got 17 and 18.
Oh, he's 2. Oh, yes, he is. Let me call 17 as well. 24 CR 005966Y. 1 count of stalking, January of 2023. The second case, August of 2024.
Third arrest, 2010, possession of marijuana. I don't know if the state has something different.
The only other thing I have is he has a 2007 arrest out of South Carolina for driving without a license.
All right. Go ahead, State.
For
Which one? You want to do 17 first?
Yes, Your Honor, that would be.
Okay.
For position 17, stalking, the defendant is accused of stalking the victim, Ann Pearson. The defendant called the victim several times, has come by and banged on her door, and will not stop harassing the victim. The victim told officers that she had known the defendant for about 1.5 years, and she did send videos of the defendant at her door banging on it. The state is just concerned because these allegations are very concerning. She's obviously asked him to leave her alone, and he continues to harass her. So the state's recommendation is a $2,000 surety bond, no further contact with this victim, stay away from the incident location, which is her residence, 765 McDaniel Street, Southwest Atlanta, and no drugs, weapons, or alcohol. The state would ask the court to sound for the victim, Ms. Ann Pearson.
All right, Ms. Ann Pearson. All right, go ahead, PD Wills.
Thank you. My client has not had any contact with the alleged victim in this case. Since this time, he wasn't actually trying to attempt to contact Miss Pearson. But again, I would remind the court that this happened in January of 2023. There have been no further incidents or occurrences between my client and Miss Pearson. I am asking for a signature bond. My client is 35 years old. He's a native of Georgia. He doesn't have any significant criminal history. He does have a high school diploma and some college background, no children. He does not reside at the location, has no need to go and return to that location. And again, as I stated, has had no contacts with that alleged victim since 2023 of January. So I think that a signature bond would be most appropriate in this case. My client does work as a cook at a restaurant here. He does have a shift coming up, and is hoping that he can be bonded out so that he can maintain his employment.
No, it is a long time ago. Have State, have you had any contact with the victim?
No, we have not. We've reached out to her, but we haven't been able to make contact.
And it's just a delayed arrest?
Yes, Your Honor.
And then the other case, pedestrian in the roadway and obstruction, so I'm not comfortable giving a signature bond based on the charges, but the fact that it's over a year ago makes me wonder, but I want to make sure the victim is safe.
She is, Your Honor. It's my understanding that the alleged victim in this case is actually the mother of a friend of the defendant. So he has no reason to be involved with that person and has not had any contact with the mother of the person he had a relationship with.
Well, the state has not had an opportunity to speak with this victim to confirm that he hasn't reached out or tried to communicate with her again. And like the warrant said, he was calling her, coming to her door, banging on it, wouldn't stop harassing her. So there is just a slight concern for her safety. Not slight, there is a concern for her safety.
Right, and this is all just allegations, Your Honor. So again, and there has not been any, this is 2023 of January. So there have been no further incidents. My client has not been back there. So there has not been any additional concerns since she called the police.
All right, just to err on the safe side, I'm going to grant a $2,000 surety bond. I'm going to ask that he stay away from 765 McDaniel Street. No further contact with Ann Pearson. No drugs, alcohol, weapons, or guns while on bond. All right, next case, state.
Yes, Your Honor. In this case, the defendant is accused of being in the middle of the roadway at the intersection of Metropolitan Parkway Southwest and Lillian Avenue Southwest while traffic was passing. When officers attempted to detain the defendant for the possible warrant that was out for his arrest for stalking, the defendant ran and ignored multiple commands by officers to stop. The state's recommendation is going to be a signature bond through the jail, no drugs, weapons, or alcohol while out on bond.
And Your Honor, again, I'm sorry, my client may have been confused about the charge since I guess why they were trying to arrest him arrived from a case that derived from January 2023. I would again ask that my client be given a signature bond in this case, as there have not been any difficulties between my client and this alleged victim. It seems maybe this alleged victim is trying to, I don't know, have something to do between her meddling between her daughter's relationship between my client and her daughter, but there have not been any difficulties. My client is working and he's very concerned about losing his employment. He also has difficulty with housing. He does have a mailing address, but does not have housing, is working toward housing. So his job is very crucial. And so him remaining in jail would put him at risk of further homelessness as well as losing his employment. So I would ask that Your Honor reconsider the previous bond and also give him a signature bond in both cases.
Well, we did request a signature bond for the pedestrian roadway and the willful obstruction. Again, we have not had a chance to speak with this victim in the stalking case, and there is a literal video of him banging on her door per the warrant.
All right. What I'll do is with this second case, $1,500 signature bond through the jail, 1,000 on the obstruction, 500 on the pedestrian in the roadway, no drugs, alcohol, weapons, or guns while on bond. And so that's the signature bond on the second case. First case, I'm still a little cautious on that, and it's a very serious charge. There's video of it happening. And so, you know, that going through a bond, I guess at 10% is $200.
I do understand that, Your Honor, but my client is struggling with homelessness. He's just a cook. And this did happen January of 2023. That is a year and a half ago.
But it
There's
still
been no
happens.
other,
It's still
I'm
happening.
sorry, I was still speaking. I'm sorry if you could just give me a moment. No, there's been no further incidents between my client and the alleged victim for a year and a half. So I think that is good faith on my client's behalf that he has no intent or desire to reach out or contact Miss Pearson.
Right. Well, it's a low bond, you know, I will take it down to 1,500 so that it'll be the same on each. One is a surety and one is a signature. Okay, all right, thank you.
Have a seat, right? Next, we go to position number 12, Mr. Hill.
Who is this again?
Well,
Position
Hill,
Hill.
this is 24 CR 005959A Armand. Sorry, Rashad Armand Hill, one count of criminal trespass, retrial.
11. Last arrest was in July for trespass. It's 24 CR 005137A. Got ag assault, criminal trespass, 2 counts. Simple assault, 23 CP 217171. On probation for trespass out of DeKalb County. 2023 probation, 2023 FTF.
Okay. State.
Yes, Your Honor. In this case, the defendant entered the property belonging to Mr. Mark Lewis and the victim Kennedy Lewis, the backyard at 2586 Black Forest Trail in Atlanta, Georgia, on July 27th, 2024, after receiving a criminal trespass warrant for going there without the victim's consent. The incident that the defendant was released on was the case number that was cited by pretrial was 24 CR 005137A, where the defendant received a $1,000 good bond granted by Your Honor on July 26, 2024 for criminal trespass at the home of Mark Lewis and his family at 2586 Black Forest Trail, Atlanta, Georgia. So this defendant waited, a day after Your Honor ordered him to stay away from that location and not go back to that residence, to go back to that residence and go on the property of the victim, which required her to call the police and have him arrested yet again. For that reason, the state would ask the court to grant a $1,000 cash bond, since he clearly didn't get the message after a $1,000 surety bond, a stay away from 2586 Black Forest Trail, as well as no further contact with Mark Lewis or his family, and that is to include Miss Kennedy Lewis. The state does have concerns for the safety of this victim and for the risk of reoffense, given the almost zero lack of time that he waited from the time he got out of jail to go back onto their property. We would like to sound for Miss Kennedy Lewis and Mr. Mark Lewis if either one of them are here. And we also are asking for no alcohol, drugs, or weapons as a condition of the bond. That's all for the state.
Okay, the Lewis is here. Nope. All right, go ahead, PD. Holly.
Sorry, may I request a breakout session really quick on this one?
Is there anyone left in the courtroom? I think it's not. Or do we need?
There's a Galaxy.
There's one other person left in the courtroom.
Okay, let's do a quick breakout. And I keep asking who's this Galaxy S23? Is that an employee or is that a victim who's waiting on the case? Can they answer?
Yeah.
Looks like they unmuted themselves.
Yeah.
Who's on Galaxy S23?
Hey.
Yes, ma'am. Which case are you here for? Can't hear you.
She said
Price's
she's someone
mom.
Price's
Price, mother. Yeah, we already did Price.
Yeah, we already addressed that case.
Oh, you
1500
did?
SOB jail. Yeah.
Mm-hmm.
I
Yes,
didn't
ma'am.
hear. I didn't
Yes,
hear
ma'am.
you.
We did already address that case. Your daughter received a $1,500 signature bond through the jail,
Okay.
which means she's going to sign herself out, so she should be.
Yes.
Okay, thank you, thank you.
Thank you.
Thank you. Have a great
All
day.
right.
All right,
Yes.
you too.
Okay. All right, but there's one other person in the courtroom, I believe she stated.
Broken. Oh.
She did. We gotta stay seated. Right, yep.
All right.
Yes, Judge, I'll just defer for the court to the court based on our discussion in the breakout session.
All right, Mr. Hill. I'm going to order an MHET and I'm gonna put you on a different calendar, the competency calendar. And you've already violated my previous order. So instead you tell me I was gonna order the 1,000 cash bond. Because we judges do not like when you violate our orders.
The state would ask that for that bond still, and it can be adjusted up
Once
after.
it gets on the.
That is
Yeah.
correct.
Okay. All right. So that's a 1,000 cash bond. And you are to once again have no further contact with Mark Lewis or Kennedy Lewis or anyone in the Lewis family. And stay away from the incident location or the addresses where they live and or work. And no drugs, alcohol, unprescribed medication, or weapons or guns while on bond. I think that should do it.
Next, we go to position number 3, Mr. Brookins. And before we start, was the simple assault NOD?
Pardon?
The third charge that's on his booking sheet is not on the calendar, so I
That
was
is correct. I did the NOD and sent it out already to the jail active records.
Okay, thank you.
Thank you.
24 CR 005960A, Alvin Brookins charged with stalking and harassment communications, pretrial.
17/2020 forgery and counterfeiting conviction. 2011 aggravated child abuse that was dismissed. 2010 felony battery. It's no action was the disposition.
Okay.
So, Your Honor, this happened on August 14th of 2024. Miss Petra Fairley stated that the defendant had been harassing and intimidating her, had left voicemails on her phone, provided, the officer was also provided text message threads which outlined a history of him stalking her at her job. Once she left work on August 14th of 2024, the defendant chased her south on Roswell Road while driving a black Can-Am three-wheeler. He began screaming that she was a bitch, a whore, demanded that she talk to him. All of this was captured on the city of Sandy Springs traffic cameras that showed him pulling up beside her in a reckless manner, both the left and right side of her vehicle, and began hitting her window, demanding that she speak with him. This started at the 8700 block and continued for 5 blocks to the 8200 block. Based on this and the fact that he showed up at her job, which was located at 1010, let me just get the address, 1010 Hunt Cliff Northeast, Sandy Springs. The victim is very much afraid for her safety. We have had an opportunity to speak with her. In speaking with her, she stated that she met the defendant 3 years ago. They were friends. She stopped being his friend, and then he began stalking and harassing her. She confirmed the events in the warrant, stated she's afraid of the defendant. She just wants him to leave her alone. She wants a no contact and a stay away from her work address, the 1010 Hunt Cliff Northeast Sandy Springs, and her residence, which I will put in the chat. And she wants, as I said, no further contact and a stay away. We are requesting a $5,000 surety bond on this case. We are asking for $2,500 per count, no further contact with Miss Petra Fairley, stay away from her residence and her place of work, no alcohol, drugs, or weapons, and specifically no firearms. That's all for the state. We would like to sound for Miss Petra Fairley. Sorry.
Miss Petra Fairley. I think we're the only ones left. I believe. VAG.
No, that's our victim witness advocate.
Oh,
So it does not appear
VAG,
she
that's
is
what
here.
that stands for.
But she did, I would amend, she did say she would not be on Zoom, but did talk to our victim advocate.
Okay. All right, good. So we're good. All right. No. All right, go ahead, PD Holly.
Yes, Your Honor. My client is 52 years old. As you heard, he doesn't have any lengthy criminal history. He is a widowed father of 3 children. His wife died about 6 years ago, and he cares for them full time as a father. We are asking, we have no issue with the stay away, with the no further contact. Please place that in order. He does not want to have any additional contact with her. He does deny some of the allegations. He says that a lot of that didn't happen. He did not recognize earlier in the time that she did not want to have contact with him. And he says the last time that he saw her, which was months ago, she asked him to leave and he did. We would ask for a signature bond. I believe that that's appropriate in light of his history and the situation. We don't have any issues with no contact. And don't have any issues with the no weapons or guns either.
All right, I'm going to order the $5,000 surety bond, $2,500 on each. I'm going to order for him to stay away from the work or residence of this victim, Miss Petra Farley, is it, or Fairley?
Fairly.
Yes, Your Honor, Fairley.
Fairly. So he's got to stay 200 yards away from her. And sort of appalled by the conduct, and want to make sure that she's going to be safe and not have to be harassed or anything else by this defendant. And I realize there are allegations. Please don't interrupt me. And I'm going to order that no further contact and the stay away. I'm going to also order no drugs, unprescribed medication, alcohol, weapons, or guns while on bond. That's it. 5,000 surety. That it?
Your Honor, there was one case on the calendar. I don't know if the court would want to revisit it. Number 9, Kevin Davis. In the comments, it said it was reset. Attorney Cook left the court before the case was heard. Judge Williams issued a $2,000 good bond, but if the PD's office wanted to assert a argument on that for a different bond, that they may do so. But I don't know if the PD's office was aware of this case.
So I saw that, but we're not aware of, and he wasn't brought out, so we haven't had a chance to speak with him. If he's can be brought to us, we would love to help him try to get a signature bond. But I don't have any information about the case or him at this point.
I will say he's currently been in jail for 101 days on a 19, 20, 21, 22, $22,000 surety bond on a PI case and an FTAA. So if it needs to be reset to Monday, it will not change his position.
Okay, let's do that and we'll let Attorney Cook handle it then.
Okay.
That makes more sense.
Okay, reset to Monday. I think that's it.
Yes, Your Honor. I believe that's
Looking back
everything.
through.
How much longer you got, bro? You got a long way to go.
Yep, that's all the cases. All of them are highlighted on my calendar, so they've all been addressed.
Courtroom 2, can you mute?
I got it. Position 1 is a $4,000 sign-on bond jail, $3,000 for count 1 and $1,000 for count 2. Position 2 is a $5,000 surety, reset SAP, $2,000 on count 1 and 3 and $1,000 on count 2. Position 3 is a $5,000 surety, reset SAP, $2,500 per charge. Position 4 is a $1,000 sign-on bond pretrial, level 1. Position 5 and 6 are also $1,000 sign-on bond pretrial, level 1. Position 7 is a $5,000 surety, $2,500 per charge, reset SAP. Position 8 is a $3,000 sign-on bond pretrial, level 2. I got $2,500 for count 1 and $500 for count 2.
Per judge.
Per judge, yes, okay, that's nice. Position 9 is a reset to Monday's SCA calendar. Position 10 is a $1,100 sign-on bond jail, $100 for count 1 and $1,000 for count 2. Position 11 is a $1,000 sign-on bond jail. Position 12 is a $1,000 cash bond, reset SAP. Position 13 is a $3,000 sign-on bond pretrial, level 1. Position 14 is a $1,500 surety, reset SAP. Position 15 is a $10,000 surety, $5,000 per charge. Position 16 is a $2,500 sign-on bond jail. Position 17 is a $2,000 surety, reset SAP. Position 18 is a $1,500 sign-on bond jail. $500 for count 1 and $1,000 for count 2. Position 19 is a $5,000 cash bond, reset SAP. Position 20 is a $1,500 sign-on bond jail. Position 21 is a $1,500 surety, reset SAP. Position 22 is a $2,000 sign-on bond jail. And position 23 is a $3,000 sign-on bond pretrial, level 1.
All right, any questions or corrections?
Position number 17 was reduced to 1,500.
Oh, let's see. I did reduce 17 to 1,500.
Oh, did you?
And
Is it
position
still a
number
surety
12,
bond?
Yeah, still a surety, but I reduced it to 1,500.
Okay.
and position number 12 is going to reset competency, and I'm filing for MHD.
Right.
And you're, Mr.
Hold on, did you get that on 12, Michael?
I did just.
Right,
Okay.
I was gonna ask if we can put it on the 9/5 competency calendar.
Okay.
Thank you.
And I'll let Ms. Melnick know as well to expect him, or Paul.
Thank you.
Mm-hmm.
No.
And
That's
that's it. All right, thanks,
Happy
everybody.
Monday.
Have a good weekend.
Thank you. Have a good weekend.
Thanks.
All
Have a
right.
good